Supreme Court judgment has reignited a fundamental constitutional debate. Does conversion erase caste identity in the eyes of law? And this question is echoing across the country. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand this Supreme Court judgment in detail. So let us begin with understanding that what exactly has Supreme Court said. So when we are talking about this particular judgment, Supreme Court has clarified that if a person converts his religion, then the protection that is being given for a specific caste that will not be provided. That means conversion to any other religion will lead to immediate and complete loss of scheduled caste status regardless of birth. And this has been said by the bench and it has invoked the clause 3 of Constitutional Order of Scheduled Caste of 1950. Now let us try to understand layer by layer, starting with that what exactly is the case. Now this case is about a person who belonged to Madiga community, which is a scheduled caste community. Now he had converted to Christianity and he had been working as a pastor for past 10 years. Furthermore, as per the records, there had been no reconversion. That means he had not returned to reconverted to his original faith. That means he remained Christian. He was preaching Christianity as a pastor for last 10 years. Now the case commences when he files a complaint using the SC/ST Atrocities Act against a certain person. Now when he is claiming that he has been tortured, he has been given threats based on SC/ST Atrocities Act, that person against whom this case was filed, he brought in the fact that this person cannot invoke the SC/ST Atrocities Act. And that is where the judicial journey began. So it went to Andhra Pradesh High Court in 2025 and Andhra Pradesh High Court gave the judgment that SC/ST Atrocities Act cannot be invoked and the charges based on SC/ST community, they need to be quashed. Now this very appeal went to the Supreme Court and Supreme Court has upheld the High Court ruling, saying that if he is continuing to profess Christianity at this given time, that means he is ineligible for the scheduled caste status and the protections that come from that given status. So this is the whole case and the judicial journey that it followed. Now let us move to understand that what exactly Supreme Court has said. Now Supreme Court has said that when we are talking about conversions, it leads to immediate loss of scheduled caste status. Scheduled caste status will remain dependent on, and it has been dependent on, the religion that the person is practicing. It will not be based on the birth of that person. And anybody cannot claim the scheduled caste status while they are following any other religion. So no SC/ST Act or any other act that benefits this community will be applicable to these particular people. And also in this context, Supreme Court has also said that caste certificate will become irrelevant once the conversion has happened. So that means there will be loss to the SC/ST Act protection as well that was given. And if at all they want the protection, then they have to prove their scheduled caste status with proper evidence. Also there has been a provision. Also Supreme Court talked about reconversion. That if there is a scenario of reconversion, for example, a person converts to Christianity and then reconverts to Hinduism, that should come with proper strict proof and if the community is accepting that or not. Furthermore, Supreme Court has said about scheduled tribe status that when we are talking about scheduled tribe status, it is fact based, that is not automatically lost. That is something different. Facts need to be checked and based on that, scheduled tribe status would be decided. But in context of scheduled caste, these are the key things that Supreme Court has gone ahead and clarified. So the key legal findings are there will be loss of scheduled caste status. Scheduled caste status is limited to Hindu, Sikhs and Buddhist conversion will lead to complete disqualification. There will be no dual identity that will be maintained, and Scheduled Caste, Scheduled Tribe Act will remain inapplicable in case of conversions. And also that the caste certificate will not be the final proof. Now, when we are talking about these key legal findings, we also need to look at the same time into what is the constitutional framework that guides this. So, the first thing is Article 341, which talks about that how President has to specify the scheduled caste list. However, Parliament can clearly amend this. And then we also have the Constitution Order for SC community, that is from 1950. It restricts the scheduled caste status only to Hindus originally. Later it was given to Sikhs in 1956 and Buddhists in 1990. But it clearly excludes Christians and Muslims. So this is the constitutional framework which is backing the legal findings that we just talked about. Another important thing that we need to discuss, that what is the debate around it? Why are we talking about it so much? What are the dimensions around it? When we look at it, we get to see that the first thing that arises, that when we are talking about legal framework, it differs from social reality. Because if at the ground level you see, the caste realities are very different. So in this you have to understand that caste will persist even after conversion. So will the problems that come with the caste, so will the issues, so will the discrimination that exists, that is going to persist. If the law is being made and it is assuming that exit from caste system is happening, then it is away from the social reality. Other than that, it is also raising a debate about equality and religious freedom. When we talk about right to equality, at the same time, we have to keep it on the opposite side of right to practice our freedom. So it creates a tension within the fundamental rights as well. Apart from that, this has created a debate for inclusion. Because when we are talking about the scheduled caste community coming from any religion at all, they are also seeking this status. This is not something that is coming anew. Ranganath Mishra Commission has already supported that. And the concerns are not just limited to debates. The concern is about administrative challenge as well. Because this is not just about the scheduled caste status, it is also about conversions, forced conversions and the anti-conversions laws that exist. So this situation makes it genuine conversions to be identified, and the difficulty that comes along a little more up the notch. It also raises question that how the social disadvantage would be understood if the law is not taking this consideration in the given legal framework as well. Now, as a result of this Supreme Court judgment, we clearly get to see that there has been reinforcement of strict constitutional interpretation. Yes, it has again reignited the debate of reservation policy and social justice framework on the grounds that we have just discussed. But as of now, if we are looking towards the times ahead, it is an important need that we revisit the 1950 order with due considerations. We focus on empirical data rather than just the legal framework, and focus also on balancing our fundamental rights, be it about justice or be it about freedom. Now that was all from my side. Let me know your thoughts on this particular topic. I'll be leaving you here with a prelims practice question. You can put down your answers in the comment section. I'll be waiting for them. That was all. Thank you so much.